Now it's time for Brisbane's Legal Lowdown with Attwood Marshall Lawyers. Most of us have been there. You spend some serious money on a product or service and it doesn't deliver. Maybe the car breaks down a month after you buy it, the renovations are left half finished, or solar system you were promised would cut your power bill just doesn't work. It's frustrating. And for a lot of people, the bigger question is, what can I actually do about it? Well, to break down your rights as a consumer and what options are available when things go wrong, we're joined by commercial litigation lawyer James Griffin from Attwood Marshall Lawyers. James, welcome to the studio.
Thanks for having me.
This is a big issue, isn't it? And so many people, I suppose, do you find sometimes when they are affected that they suffer in silence and don't know that there's potentially help out there for them?
Yeah, they do. I find that, they don't have that familiarity with what rights are available to them. And so they don't know what recourse they have and what options are available.
And there are plenty of options. And I suppose the first thing to do is get on the phone and find out where you stand legally.
Yeah, it is. So my recommendation is always to seek legal advice early, but you can also do some research yourself. So a lot of these guarantees and a lot of these protections are contained in the Australian Consumer Law, which is under the Competition and Consumer Act. It's been around since 2011, and that really provides an outline about what rights are available to you when you purchase goods or services, and you can do a bit of research yourself as well.
Now, as far as we often hear about major and minor faults when it comes to faulty products, what's the difference and why does that matter?
Yeah, so the reason it matters is because it really governs what sort of remedy you'll be entitled to. So the best example I can give is in relation to a car. So if you purchase a car and there's some sort of fault with it, and that fault renders the vehicle completely inoperative, so that means you can't use it, you can't drive it, well, then it's likely to be a major fault. Where there's a major fault, you're entitled to a refund, repair, or replacement. So they're the options that are available to you. Where it's a minor fault, you're only really entitled to a repair. So you can't elect to have a refund or replacement. So that's where the distinction matters. That might be like the side step on your ute falls off. So in that instance, it doesn't render the vehicle inoperative, but, you still need it fixed.
Yeah, it's what we call, a lemon and so forth. And plenty of people have had experiences with those over time and probably have done the negotiating with dealerships on their own.
Yeah, which I don't envy them. It's not an enjoyable process.
Now, if a business offers to fix the problem, does the consumer have to accept that or can they insist on a refund?
Well, look, it really depends again on whether it's a major or minor defect. If it's a major defect, then, they have the options of a refund or a replacement. But if it is a minor defect, likely the only remedy that you would be entitled to would be a repair. So in that instance, you might look to accept it.
Some companies, they handle this better than others, don't they? So
They certainly do.
Yeah, like you look at a behemoth like Apple, usually, and they can afford to because they are one of the biggest companies in the world. Usually if you have a defect with your iPad or phone, that they're so quick to fix. And boy, some others, it's like getting blood from a stone.
It is. It's primarily those family-owned companies or those independent businesses, and that's typically because of they're under-resourced, or it's a little bit more challenging for them to source products or fix the defect or the issue.
Yeah. Now, if a consumer has tried to resolve the issue, but the business still won't cooperate, what practical options are available for them?
Yeah, look, so again, my recommendation is always to seek legal advice early on. That way you understand what rights are available in your specific circumstances. But as a general statement, look, my recommendation is to write directly to the supplier of the good, seek to resolve it. If you can't do that, the best outcome is that you now understand their position and their willingness to negotiate, and you would look to make an application to a tribunal. So in Queensland, it's the Civil and Administrative Tribunal, and you would seek to have it heard by a member and hopefully get the outcome you're looking for.
Yeah, this might be a tough one for you to answer, but is there a good success rate?
It really depends on the circumstances of the case. I know that's like an age-old lawyer
Yes.
saying it depends, but it really does depend on your circumstances. What records you have really govern your success rate, I suppose.
And I suppose looking at it from the other side, the companies involved have to be careful as well because there might be a fault with the product, but that might have been caused by the consumer as well, who, if it's for a smaller item but still very expensive, dropped it on the way home, for instance, or something like that. So I suppose you've got to look at this from both sides because some will try to pull the wool up, sheet over their eyes, so to speak.
You're exactly right. And I suppose that's why, it's reasonable for the supplier to do their due diligence, really undertake an investigation. I don't think there's anything wrong with that. But where it becomes an issue is where the supplier starts to drag out that investigation, hold the consumer out, and they're left along and they don't know where they stand.
One of the big ones that we hear about often is unfinished buildings or unfinished builds. And it could be when building or construction companies that they fall by the wayside. Where do you stand there in general terms?
Yeah, so interestingly enough, there are some provisions under the Australian consumer law that apply to that. They're not these general protections that we've just been talking about. They might relate to misleading or deceptive conduct, and there's a few provisions that they might capture. And that primarily relates to, where there's some sort of representation by the builder about the quality of the work they're going to perform, or, the work that is to be done, and where they don't comply with that, there might be some remedies under the ACL. But there are other remedies available in that instance, and again, they'll be tailored to, the nature of the defect and the building is done.
Yeah, and because they're the big ticket items, aren't they? When you're talking about builds, you're talking about cars, that's where you can really get hit hard. And if you don't, I suppose, explore your avenues legally and realise that there's avenues out there, it can cripple you as an individual.
Well, it can, and there's another consideration here, and you mentioned it previously, and that's where the builder shuts down or goes bankrupt. And it's that saying that you can't draw blood out of a stone. And so something to be aware of is, that builder might have done the wrong thing, but that business might go bankrupt. You need to consider, okay, can I actually recover from that builder? Do they have any assets that, even if I'm successful in pursuing them in a court in a litigated matter, can I actually recover any money from them? Because they might not have any assets that I can recover against.
And then you got to work out the costs it would take to go down that path to recuperate some you could have put into another builder to come and finish off the job.
Well, that's right. And that's why, when an individual comes and they speak to me about building matters, I always urge them to consider the commerciality of the matter. Is this something that it's worth throwing money at? And it's important for all lawyers to undertake an investigation early on as to the assets of the builder or whoever the other side is, to provide advice about whether this is something that's actually worth pursuing.
All right. Interesting topic because, as I said right at the start, I'm sure plenty of people have come across, or know someone, family or friends that, have been, I suppose the best word to say is dudded by a company in the past, but it's nice to know that there is help out there.
There is, and I always urge people to get legal advice early on. That way they know their rights and they can understand if this is something that's worth pursuing. Okay.
It's been great to have you in the studio to talk about this because it is an important topic. As we say, it's something that affects so many different people. We've got one other final question. Is there a way you can try to protect yourself legally prior to a build to start? Is there an avenue that you know of, or have you been called in to say, hey, we're going to demolish this block and put in, say, a couple of townhouses? Can you do a background check on who to get in to try to build here?
Yeah. So
get ahead of the problem, so to speak.
Yeah. So there is some due diligence steps that you can take. That primarily looks like, looking up, okay, if it's a builder, for example, they have to have the relevant license. In Queensland, that's with the QBCC. So, for example, if it's a retail premises, only certain builders are qualified to undertake shop fit outs. Others are qualified to do residential building, but they're only qualified to do, say, up to 2 stories. So really qualifying the builder or whoever the contractor is that's going to do the works and ensuring that they have the appropriate licenses and the appropriate insurance. And that's the best way to protect yourself, because there is insurance that's available if the builder does the wrong thing. But it's important to undertake the due diligence to ensure they have that insurance to begin with.
All right, well said. James, thanks for coming in today. And I know that if anyone needs to get some advice from you, they can contact you through Attwood Marshall Lawyers.
Thanks very much for having me.
Yeah, good on you, James. James Griffin there from Attwood Marshall Lawyers, commercial litigation lawyer on 4BC Afternoons.